Thank you, Mr. Chairman, and thank all of you for being here today. We appreciate your presence. Commissioner Carr, I want to ask you, I understand that the courts upheld the FCC's previous rules to streamline the broadband permitting process under Chevron. Now that the Supreme Court has overturned that decision, how important is it that Congress act to codify those provisions?
Thanks, Congressman, for your leadership on this. I think the legislation that you've been leading on, the American Broadband Deployment Act, would codify a lot of really smart ideas that would turn things around in this country and make sure that we can start actually building out broadband in a cost-effective way. So I think, particularly in light of Chevron, as you noted, having Congress step in with clear authorization for this can only help.
Commissioner Symington, would you comment on that as well?
Yes, absolutely. The past permitting reform at the FCC greatly increased build-out speed. It's, however, in the post-Chevron world, seeing action on this from Congress could only benefit closing the digital divide.
Great. Commissioner Carr, does the new digital discrimination regime adopted by the Commission's majority put the Commission and, by extension, the trial bar in a position to second-guess deployment decisions made by broadband providers?
Yeah, this provision was a one-page provision of law tucked into a 1,000-page bill. And the way the FCC read it, it was as if it conveyed more authorities than the entire 1934 Communications Act in every single statutory provision passed since then. There is no limit under the FCC's reading to its authority now, whether it's Wall Street or Madison Avenue or construction crews or even governments itself are now subject to second guessing by the FCC here in Washington.
So essentially, how would the need to defend against these challenges likely decrease investment and risk-taking by broadband providers?
We now have unlimited liability based on the FCC's digital
Exactly.
equity rules. If you take an action, you may be liable. If you don't take an action, because it covers emissions as well, you might be liable. And so it gives no certainty to the capital allocators that need to put, and that we should want, billions of dollars to go into our networks.
Let me ask you about Loper Bright and the Supreme Court's decision there. Does that affect the FCC's recent digital discrimination rules?
I think the digital equity rules and the Title II rules, in my view, were always going to be subject to the major questions doctrine, not Chevron. But fundamentally, Chevron reinforces the idea that the framers want you here in Congress to make these decisions rather than having the FCC or other agencies take a provision of law that doesn't address an issue or only does so in an ambiguous way and claim expansive authority. So I think the Supreme Court's decision reinforces the constitutional structure of the people's representatives here making these fundamental decisions about what the federal law should be.
What about you, Commissioner Symington?
Well, on the merits, I don't know how I would comply with the digital discrimination rules if I were in the position of having to make those decisions in business. And I also don't know how we're going to enforce them. It doesn't seem that there are any real standards, as Commissioner Carr said. Anything that you do or fail to do may be attributed against you. So I agree with his analysis that this would likely come under major questions doctrine and not Chevron. Nonetheless, I also agree with his statement about how the Supreme Court has allocated the balance of responsibilities. Okay.
Commissioner Carr, disparate impact. That does not appear in Section 6506 of the IIJA. Given the complete absence of that and the complete absence of the explicit direction by Congress to employ such a standard and rules to prevent digital discrimination, do you believe the Commission has erred in adopting such a standard in its new rules?
It did. The FCC created a record to look for instances of discrimination in the broadband market. And after 2 years, the FCC said its record indicated that there were no such instances of discrimination. Nonetheless, the FCC adopted the strong medicine of this disparate impact theory, which means even if you have no intent to discriminate, the courts could come in and second guess it. What the courts have said is if Congress is going to create a disparate impact theory of liability, it has to use very clear, specific words, again, because it's very strong medicine. Those words were absent from this statute.
Commissioner Symington, you have anything to add to that?
Just that, again, the reach of this also needs to be emphasized. Commissioner Carr mentioned that it reaches construction companies. It reaches anyone who in some way limits access, even if involuntarily or unknowingly. So that's very broad brush.
Great. Well, obviously, this committee and this Congress got a lot of work to do to help you guys. So thank you very much for being here again. I appreciate it, and I yield back.
Thank you. The gentleman yields back the balance of his time.